Listen, thank you for coming out this morning. It was quite brutal getting here, wasn't it? That's what my friend Marcelo said, oh, brutal this morning, brutal. I said, well, it's a first world problem, but yeah, brave souls, good on you for coming. So we're starting a new topic today, that of negligence claims for mental injury. But I was just thinking, looking out at you all, as you are sort of nearing the end of your torts course, I hope you're feeling a little bit like torts lawyers now, that you know something about the area. That's all you need for practice. Just this kind of idea of an overview of what some of the torts are, quite a bit about negligence, which is the main tort that you will use in practice. And so it's quite a thrill to sort of feel as though you're, I don't know, entering the club in a way. So good on you. Stick with it. This Part 2 year, these courses are your building block courses, the most important ones really. So it's quite exciting, I think, for you. And for me to see another generation of gorgeous tort lawyers growing. Okay, so over the next 4 lectures, we're going to be looking at claims for negligence causing mental injury standing alone, unaccompanied by bodily injury to the plaintiff's person. Mental injury consequent on physical injuries or property damage or other types of damage, a claim for those, for compensation for those, can be tacked on to the primary claim. So we're looking at mental injury suffered alone. This is one of practical importance for New Zealand, and as I'm sure you've appreciated already, since we know from Queenstown Lakes and Palmer that civil claims for compensatory damages, this is one of the areas where the ACC regime is not comprehensive. Civil claims for compensatory damages can be brought in respect of pure mental injury, unaccompanied by bodily injury. They're not barred by Section 3171, the statutory bar provision, and the reason for that is the definition of personal injury in Section 26(1), which says that only mental injury suffered because of physical injuries covered by the Act is personal injury, and so covered by the scheme. In the workshop, we looked at mental injury when there is physical injury, but it's not suffered because of physical injury. There was that kind of very clever residual sort of claim, but by and large we're not looking at that, we're looking at pure mental injury. Remember that in addition to Section 26, the only pure mental injury covered by the scheme is that caused by certain criminal offences in Section 21 and 21A, and mental injury caused by shock-inducing events at work, Section 21B. So there's a wee summary of 21B for you. It's work-related mental injury suffered inside or outside New Zealand, caused by a single event, which is an event that the person experienced, sees or hears directly in the circumstances described in Section 28(1). That talks about defining work-related injury, Section 28(1). And this is the important bit, is an event that could reasonably be expected to cause mental injury to people generally. So this provision was put into the Act when employers realised that they were vulnerable to common law claims for compensatory damages in the kind of nervous shock type area where employees had witnessed harrowing events at work. So it was designed to stem those claims in the work related area. So otherwise, other than those situations, an action at common law for compensatory damages can lie. And so a victim of negligence who suffers psychiatric injury alone, without suffering any physical injury, can sue a tortfeasor for compensatory damages. But they have to make out the elements of a cause of action first, usually in negligence. And the Palmer case also told us that even if the primary victim's injuries are covered by the Act, the statutory bar doesn't exclude the witness, the secondary victim's claim for compensatory damages. Okay, so here's our roadmap. First, we're going to look at the policy reasons that have made courts reluctant historically to find liability in claims involving pure mental injury. Secondly, we're going to look at what constitutes actionable damage, what type of mental injury can ground a claim. And third, we'll be looking at the duty of care, the features of claims in which a duty of care will be recognised in respect of pure mental injury. The law used to inaccurately refer to this area as nervous shock claims, and that's clearly got a kind of sexist overtone, hasn't it, as well as being inaccurate. And so the category is better considered in modern times as concerned with liability for psychiatric or psychological injury. It's a special category of case where, thinking of the ANZ test for duty of care, where at stage 1, a sufficient relationship of proximity is not comprised of reasonable foreseeability alone. That's an insufficient criteria on its own to establish a relationship of sufficient proximity. Additional hurdles, and we'll be finding out what some of those hurdles are, have been imposed for there to be a relationship of sufficient proximity for duty purposes in this category of case. But, and this will be frustrating for you, there is a dispute between jurisdictions as to what those additional conditions necessary before a claim will succeed are or should be. So first of all, looking at those policy reasons, why the reluctance to impose liability for pure mental injury? Historically, there was always a bit of distrust around psychiatric conditions. You can't see the suffering as you can see with bodily injury. And we can't see the baseline before and after. So if I drive my car into yours, it's pretty obvious that I've damaged it and that it's gone from an undamaged car to a damaged car. Mental states are more ephemeral, if you like, less objectively ascertainable, and changes are difficult to measure. Lord Stein, in the Frost case, which we'll be looking at later, set out 4 policy reasons which justified these special rules restricting liability in claims in negligence for pure mental injury, particularly for what are called secondary victims. Those are the people who witness physical injury or death suffered by another person. So first, that point I just made, that psychiatric harm is less objectively observable than physical injury. And the concerns of the courts were that it's more likely to be fabricated, or that there might be claims for trivial injury, and that there's a diagnostic uncertainty between distress and grief, which are not recoverable, considered part of ordinary life and to be borne without compensation, and psychiatric harm. Secondly, there was a concern that the possibility of bringing an action might constitute an unconscious or even conscious disincentive to rehabilitation. Already there were reports of the disincentive effect on litigation with respect to physical injuries, more so the concern with respect to mental injuries, it was said. And then there are two floodgates concerns. Liability, it was thought, might increase the class of potential plaintiffs, the class of persons who could succeed in recovering a claim. And finally, there's this disproportion concern that liability would result in a disproportionate or unreasonable burden of liability on the defendant relative to the tortious conduct involved. Recently, in a case we'll be looking at later called Paul against Wolfhaven, the Supreme Court of the United Kingdom visited these policy concerns and said, actually, it's only the last one to which we would give any weight, this concern about opening the door too wide to mental injury, resulting in too heavy a burden of liability on defendants. And this idea is repeated in the textbooks, and on the slide I've put an example from Prosser and Keaton. Entirely unreasonable burden on all human activity if the defendant who's endangered one person were to be compelled to pay for the lacerated feelings of every other person disturbed by reason of it. There's also a particular concern in this category of case about causation issues. So what do I mean by that? Proving that necessary causative link between the negligent conduct and the mental injury allegedly caused. There's not the same transparency or clarity of the state of the plaintiff's mental health pre and post the negligent event that exists with physical injuries. And there's also a concern that mental injury might have a slow onset and be diagnosed over time, so that it can be more difficult to identify exactly what the cause of the mental injury was. But courts have always had to grapple with difficult causation issues, as we've just seen. So this factor on its own certainly could not prevent recovery. So we're going to see that there's a variation in approaches taken in different jurisdictions to liability and negligence for mental injury. The United Kingdom, we're going to look at quite a few cases from that jurisdiction, has very firm restrictions on the recoverability of pure mental injury. The High Court of Australia has a more relaxed approach, and Canada is even more relaxed again. New Zealand, our last case is somewhat elderly, 1999, Court of Appeal decision in Van Zoest. And so we haven't had a Supreme Court decision in this area. And so the Supreme Court's yet to rule definitively on the subject. So we don't actually know where New Zealand stands. At a rough guess, it probably stands, from the indications in the Van Zoest case, somewhere between the High Court of Australia and the United Kingdom. But that's why we have to understand the merits of the other jurisdictions, because we are ball-gazing to some extent to see where the New Zealand common law in this area might head. Crystal ball gazing. Okay, that first question. What type of mental injury is actionable as damage? Initially, the courts would only impose liability if the shock caused physical consequences to the plaintiff, such as a miscarriage or a stillbirth, which occurred in a couple of cases. But liability wasn't being imposed for the mental injury at all. It was being imposed for the physical consequences of it. But the common law developed, and liability will now be imposed for psychiatric injury unaccompanied by any physical consequences. So, bottom line, the view taken in the United Kingdom, Australia, and for the time being in New Zealand, is that in a claim for mental injury alone, the mental injury must be a medically identifiable psychiatric condition or illness. You need a diagnosis. Severe grief, severe emotional distress will not survive. Will not suffice. Now we'll see that Canada takes a more liberal view. So on this approach, no liability for damages for nervous shock unless the shock results in psychiatric illness. Mere mental suffering, grief, emotional distress, no matter how severe, unless it's accompanied by physical injury or unless it develops into a psychiatric illness, doesn't attract compensation. One of the reasons is that these lesser states are considered part of the vicissitudes of ordinary life, something that happens in almost everybody's life that has to be borne without an award of damages. So I've set out for you the quotes, which I'll let you look at yourself. There's a quote of Lord Bridges from McLaughlin and O'Brien, and a later quote from Page and Smith. And in Australia, a case we'll be looking at later, Tame against New South Wales. The Australians take the approach, an additional reason that the requirement for a recognisable psychiatric condition reduces the scope for indeterminate liability significantly. It knocks out a lot of claims where the injury doesn't reach the level of being a diagnosable psychiatric illness, such that other control mechanisms, such as the ones we shall see have been applied in the United Kingdom, can be relaxed. So they rely on the nature of the damage as a strong control mechanism to deal with the concern about the floodgates. The position in New Zealand. This position has been adopted in New Zealand in this Van Zoest case, as I said, currently our highest authority. Quite a while ago now, this case, but we have no more recent higher authority. This case concerned claims by the next of kin of 4 patients who had died during or shortly after surgery at Christchurch Hospital, having been operated on by a thoracic surgeon there, about whom there were deep competence concerns. The relatives claimed compensation for their own mental suffering, and it fell short of a medically recognised psychiatric disorder, or at least they had not adduced evidence, medical evidence of a diagnosis. They said that they suffered this mental injury as a result of the death and suffering of their relatives on learning from a hospital employee what had happened to their loved one some days or weeks later. And also learning of the allegedly gross shortcomings of the surgeon and in the systems of the hospital. A majority of the Court of Appeal held, following England, the then Canadian law, and Australia, that a claim for mental suffering caused by awareness of death or injury to a primary victim through a negligence claim can't succeed unless there's proof that the effect on the mind of the secondary victim constitutes a recognisable psychiatric disorder or illness. That's the words used. Recognisable psychiatric disorder or illness. Examples are post-traumatic stress disorder, clinically diagnosed depression, these are examples given by the court, pathological grief syndrome, and any diagnosis in, for example, the Diagnostic and Statistical Manual of Mental Disorders. So normal human emotions such as mere mental distress, shock, fear, grief, anxiety, distress, even though a foreseeable result of negligence, are not recoverable. Even abnormal or severe emotional distress, if falling short of a psychiatric illness, is also not recoverable. Now, the court gave 2 main reasons for this holding. First, they considered that this rule had the advantage of drawing a clear and relatively certain line between distress and psychiatric illness. It was an easier line to draw than, for example, the line that which would be required if the dissent, Justice Thomas's dissent, was favoured. I'll come to that in a minute. So it's difficult to articulate a workable test which would delineate what degree of distress would be recoverable if the line were lowered. So, advantage of certainty. A second reason is the floodgates, and I put that at the bottom quote on this slide. Unless the ability to claim is not restricted to those suffering a psychiatric disorder, there'll be a flood of claims by emotionally distressed secondary victims. So the court said, whilst a floodgates argument is often to be treated suspiciously, there seems to be good reason to believe that unless the ability to claim is restricted to situations in which the damage to the secondary victim's mind has been so severe as to produce psychiatric disorder, there will be a flood of claims, and that emotionally distressed plaintiffs may not be deterred by the likelihood that damages awards will be noticed. They acknowledged that medical evidence would be required to prove a recognisable psychiatric illness or condition. The diagnostic tools that the medical expert uses to determine whether or not what the plaintiff is suffering constitutes a medically recognisable psychiatric injury, they tend to use two generally accepted clinical guidelines. First is the DSM, the Diagnostic and Statistical Manual of Mental Disorders, currently in its 4th edition that I referred to before. And secondly, there's an international classification of diseases and related health problems set of guidelines, and those two are commonly used by medical experts to make the diagnosis. But they're not necessarily conclusive of the issue. Recovery has been awarded for psychiatric conditions which are medically recognisable but not listed in either manual. The Court of Appeal deliberately used the word recognisable psychiatric disorder, and this was to signal that there could be new diagnoses discovered with advances in medical knowledge. So, for example, post-traumatic stress disorder prior to the 1980s wasn't a thing, wasn't a diagnosis. So a claimant suffering from it would not have been able to recover, couldn't overcome this hurdle. But since, of course, it is now a recognised psychiatric condition. Justice Thomas dissented on this issue and would draw the line differently. He would draw the line between mental suffering which approached the order of a psychiatric illness and was outside the range of ordinary human experience. He would hold that that should be compensatable as well, but that lesser forms of emotional distress should not be. So there's a quote from his judgment. He would modify the rule that the plaintiff must have a recognisable psychiatric illness to make it a general rule that while damages are not generally available in the absence of a recognisable psychiatric illness, the plaintiff will not be prevented from recovering if he or she can nevertheless demonstrate that, although not identified as a recognisable psychiatric illness, their mental suffering is of the order or approaching the order of a psychiatric illness and therefore plainly outside the range of ordinary human experience. So that's a slightly different approach, isn't it? It's one which isn't held hostage to the current limitations of the psychiatric profession's classifications of conditions. And I think we know that the psychiatric diagnoses tend to be ones which are treatable by mind-altering drugs. So the existence of a drug often drives the diagnosis of the condition. So this instead draws a line not at medical conditions, but at suffering that's outside the range of ordinary human experience. So if it's compromising the claimant's agency in living their lives, even if it can't be treated with powerful medication, there's a case, according to Justice Thomas, for it to be included within the threshold for compensation. Canada attracted and adopted Justice Thomas's dissent in Van Zoest. Clinical guidelines relied upon by other jurisdictions, the Supreme Court of Canada said, are developed in a clinical setting. Their purpose is to help identify and treat disorders. They shouldn't be used in a legal setting. They shouldn't determine legal rules. Provided the mental disturbance is significant, it has to be serious and prolonged. It has to rise above ordinary anxieties, annoyances, fears that come with living in civil society. It has to go beyond normal grief and distress. Then it could be compensatable. Psychiatric diagnosis may assist, but it's not determinative. So, in this case, Sidati and Moorhead, the Supreme Court of Canada, approved of Justice Thomas's dissenting judgment in Van Zoest. In that case, Mr. Sidati was involved in a car accident which caused mental injury involving a change in personality, irritability, and cognitive difficulties with his family and friends. It was serious and prolonged, but it didn't fit with the diagnostic tools of psychiatry so as to be a particular medically recognisable psychiatric illness. Nevertheless, this was found to be mental injury at a level that could ground a claim in negligence. So expert evidence will be essential. It can assist in determining whether or not a mental injury has been shown, but even where a psychiatric diagnosis is unavailable, it's open to the court to find on the evidence that the claimant has proved on the balance of probabilities the occurrence of a mental injury. So we have two approaches, don't we? UK, Australia, and for the time being New Zealand require a medically recognisable psychiatric illness. Canada, not limited to medically recognisable psychiatric illnesses, providing serious and prolonged and above kind of ordinary negative feelings that come with living our lives. So New Zealand Supreme Court hasn't considered what threshold of mental injury is required. Given the developments in Canada, it's possible the Supreme Court could approve Justice Thomas's dissent, and it's possible that the New Zealand law will develop away from tethering legal liability to psychiatric illnesses. So, whose view is preferable, do you think? Do you think it's necessary for there to be a medical diagnosis? Or do you think judges are capable of working out and identifying that line between ordinary annoyance, emotional distress, with living a normal life versus something out of the ordinary, which should attract compensation. So the first thing you need for a claim is the right kind of mental injury. If you were doing a problem question, you might need to address this issue, whether there was actionable mental injury. Is there a diagnosis? If not, is it outside ordinary human suffering? You might need an argument to bring that within the realm of compensation. Second thing you need is a duty of care. Different cases of mental injury present different problems. Sometimes mental injury might be caused by being exposed to a risk of physical injury to yourself. These cases don't usually present any problem. The more difficult cases concern the plaintiff witnessing injury or death to another. These are the really troublesome cases where the floodgates is an acute concern. But the key thing to be aware of in these cases of so-called secondary victims is that the claim by the plaintiff cannot be parasitic on any duty of care owed to the primary victim, the direct victim who's suffered physical injury or death as a result of the defendant's negligence. The duty of care owed to the plaintiff's secondary victim needs to be independently established as owed by the tortfeasor to the plaintiff. Okay, so where are we heading? We're going to start with the law of the United Kingdom. We're going to look at quite a number of cases, and we'll probably spend most of our time looking at those cases. And we'll see the mess they've got themselves into in that jurisdiction before we contrast it with the law in other jurisdictions. And why do we care about this? The reason, as I've said, is that we live in New Zealand. Our Supreme Court has yet to consider these issues, so it's important to consider the merits of the paths taken in these other jurisdictions to whom we commonly look. So let's start with McLaughlin and O'Brien, which I asked you to read for today. So the plaintiff's husband and 3 children were involved in a serious road accident caused by the negligence of the defendant. The plaintiff's wife and mother was informed of the accident about 2 hours after the event, and she was driven to the hospital, and on arrival she learned that her youngest daughter had been killed in the accident. She then witnessed harrowing and chaotic scenes at the hospital. She saw her husband and 2 of her children, who were still to be treated, bleeding, covered in dirt and oil, with unset injuries and in considerable pain. Eventually, a few weeks later, she suffered severe shock then, but it resulted in a psychiatric illness that arose a few weeks later. And she's suing the defendant for her mental injury. And the question in the case was, did the defendant owe her a duty of care in negligence? Now, the normal ANS test at the time was applied. They don't do that anymore in Britain. But the issue is whether there's a sufficient relationship of proximity. And the court says reasonable foreseeability of that she might suffer shock and psychiatric illness is insufficient to constitute a relationship of sufficient proximity. So the court in this case is concerned with the House, concerned with what are the additional requirements that go to make up a sufficient relationship of proximity in this category of case. You see how Anne's pans out in identifiable categories of case? What the elements of a sufficient relationship of proximity will differ according to the category of case. And so that's why it was said way back in Caparo that there's no fixed definition of proximity. It depends on the category of case. Okay, so Lord Wilberforce hold on, there it is, sorry, gives a description in the case of the state to which the common law had reached by a process of logical progression. I'm having trouble with my words this morning. So what was the common law? Where was it at the time of the case, 1983? And so this is a bit of history. Initially, recovery was only available if the psychiatric illness was caused by a shock which arose from a reasonable fear of immediate personal injury to oneself. So you had to be, there had to be a close call. There's a case, Julia and White, about a barmaid where a horse plunged into the bar, and she satisfied this requirement because she was unharmed, but she had a reasonable fear that she would be imminently physically injured herself. Caused her to give birth prematurely. That's the old rule, that you had to suffer physical injury, and we know that that was done away with in time also. That limitation, an immediate reasonable fear of immediate personal injury to oneself, was soon done away with, rejected by the Court of Appeal in England, and replaced with a more liberal test. The plaintiff could recover if he or she could prove their psychiatric illness was a reasonably foreseeable consequence of the defendant's conduct, but it was limited to a reasonable fear of immediate personal injury either to oneself or one's family. And family was generally limited to one's spouse and children. And so that's the Hambrook against Stokes Brothers case there. In that case, a lorry, as they call them in the United Kingdom, had been carelessly left at the top of a steep street without being made secure. The plaintiff, a pregnant woman, so many of these early cases concern pregnant women, was walking up the road and she saw it career down the hill at great speed, and she became terrified for the safety of her children, who were out of sight around a bend in the street. She suffered shock. 2 days later, she had a severe hemorrhage, which eventually killed her. So she satisfied that condition of reasonable fear of immediate personal injury either to herself or to her spouse or children. On the other hand, in Borhill and Young, this is the case known as the Scottish fishwife's case. Poor Mrs. Borhill has gone down in history as a Scottish fishwife. That requirement wasn't satisfied. That case involved a defendant speeding on his motorbike, colliding with a car and being killed. Again, the plaintiff was pregnant. She was 45 feet away, on the other side of the tram. So she was out of sight of the accident and the defendant, but she heard the sound of the crash, and later she saw blood on the road, and she suffered nervous shock, which in turn caused her to suffer a miscarriage. It was held that the defendant didn't owe her a duty of care, since he couldn't reasonably have foreseen that a person in her position would be affected by his negligent driving. She was outside the range of danger of the collision. She was never in any bodily danger, nor reasonably in fear of danger to loved ones. So liability required danger or reasonable fear for one's own or one's loved one's safety. Now, a rescuer exception had been recognised, and the case was Chadwick and British Railways. We'll come back to the rescuer situation when we look at Frost's case. And an immediate aftermath principle had also been recognised. Bottom bullet point. Apart from the immediate aftermath cases, there had been no case of liability where injury to a relative had occurred out of the plaintiff's sight or earshot. For example, where the plaintiff was told about the injury by a third person. So the plaintiff had to witness the event, the accident, to the primary victim, either see it or hear it. But the immediate aftermath principle was either an exception or an extension of that. The lower courts had permitted recovery in some cases where the plaintiff didn't see or hear the accident, but came upon its immediate aftermath. So that's where a parent hurries to the scene of the accident very shortly after and sees injured or dead loved ones and suffers psychiatric injury as a result. And so in Boardman and Sanderson, the father was within earshot of the accident and likely to come upon the scene. He did so and suffered injury from what he then saw. Similarly, in the Marshall case, the wife came upon her badly injured husband at the scene of the accident shortly after. In McLaughlin and O'Brien, the case before the House of Lords in 1983, the mother came along not to the accident scene, but to the hospital approximately 2 hours after the accident. And so the issue in the case was there sufficient proximity in time and space? Was the defendant to be liable for her psychiatric illness when she wasn't present at the scene of the accident, nor did she come upon the accident scene shortly afterwards, but she arrived at the hospital to see harrowing scenes of and distress of her loved ones and their injuries, the fact that they were covered in dirt and oil, that there were cries of pain. So it's important that there is some similarity, that they haven't all been cleaned up and they're all sedated, for example. It's important that there is the events at the hospital are harrowing. There's an equivalency to that which might be seen at the, what's the time? Oh my God! At the accident scene. Sorry, I'd go on for another hour. It's only a 1 hour day, isn't it? Okay, we'll stop there right in the middle of McLaughlin and O'Brien. I'm sorry for that. I'm looking forward to seeing you all next week. I'll put some reading up, try to keep it reasonable, and have a good weekend, you all, when it comes around. Stay dry. Hi. Yeah.
A lot of the topics that we've been doing in negligence have so many different jurisdictions that we mentioned.
Yep.
In an exam setting, would it be worth just doing the exam and maybe making something that lightly applies?
Yes, yes, yes. Cheers. You've got to think about it as if you were advising the client. Where the law is clear in New Zealand, then you stick to New Zealand. This is an area where the law is unsettled in New Zealand, and you as the lawyer, are trying to earn your coin by giving the best advice to your client about what you think the law, how you think the law will develop. So, yeah, you refer to the law in New Zealand to the extent that you know what it is, and you identify the areas of uncertainty, and you would refer briefly, I guess, to the law and the jurisdictions that we commonly look to, and you might try to make an educated guess as to which way you think we might head, or make some arguments about which way you think we should head. Does that make sense?
It does. That makes perfect sense.
Yeah.
Thank you so much.
Okay.